All right, 6050908, revocation of certificate of authority. Certificate of authority for a foreign limited liability company to transact business state when they revoked the Department of Foreign Limited Liability Company does not deliver an annual report to the Department at 5 p.m. Eastern on the third Friday of September each year. The Foreign Limited Liability Company does not pay a fee of the penalty due to the department under this chapter. Foreign Limited Liability Company does not appoint or maintain a registered agent as required in 6050113. Foreign Limited Liability Company does not deliver the filing of a statement changes under the 6050114 within 30 days after the change has occurred of the name and address of the agent unless within 30 days after the change has occurred either. The registered agent files a statement of change under 6050116 or a change was immediately in accordance to 6050114 or 6050971D. The Foreign Limited Liability Company has failed to amend certificate of authority reflecting change of the name of the record of the Department of the Jurisdiction and Information. The Department of the Service the department receives a duly authenticated certificate officially having custody of records in the company's jurisdiction formation stating it has been dissolved and no longer activity of official records. The Foreign Limited Liability Company's period of the duration expired. A member or manager or agent of the Foreign Limited Liability Company signs a document that a member of the manager or agent knew that false material respects to the intent of the document is delivered to the department for filing. And the Foreign Limited Liability Company has failed to answer thoroughly and fully the time prescribed in 605.11.1104 integrates proper pounding for the department. Revocation for the Foreign Limited Liability Certificate of Authority for the failure of as an annual report shall occur on the fourth Friday of the September of each year. The department shall issue a notice of the record of the revocation of revoked Foreign Limited Liability Company. Issuance's notice may be electronic transmission Foreign Limited Liability Company for that has provided the department with the email address. 3. If the department determines one or more of the grounds existing under the paragraphs of 1BI, for revoking a Foreign Limited Liability Company certificate of authority, the department shall issue the notice of the record for the Foreign Limited Liability Company with the department intent for the revoking certificate of authority, issuance of the notice of electronic transmission to a Foreign Limited Liability Company that has provided the department with the email address. If and within 60 days after the department sends the notice and intent to the revoke in accordance with subsection 3, the Foreign Limited Liability Company does not correct each ground for the revocation demonstration responsible of satisfaction department for each of the grounds determined if the department does not exist, the department should revoke the Foreign Limited Liability Authority to transact business in the state of the notice as required of revocation states of ground revocation issuances. A notice that may be electronically transmission Foreign Limited Company that provide the department the email address. If 6050909 reinstatement of revocation of certificate of authority. A Foreign Limited Liability Company whose certificate of authority was revoked may be applied for the Department of the Reinstatement at any time after the effective date of the revocation. The Foreign Limited Liability Company applying for the reinstatement must submit all fees and penalties that owed for the Foreign Limited Liability Company at rates that provided by the law of the time Foreign Limited Liability Company applies the reinstatement together with the application reinstatement rescribed and furnished to the department which signed both in registered agent and authorized representative of the company states. A. The name under the Foreign Liability Company is registered as transaction business. The street address for the company principal's office to the mailing address. The jurisdiction of the company formation. The date on which it becomes qualified as a transaction business statement. The company federal identification number, if and no one. Whether one has been applied the name, entitled capacity, address to have at least one person with the authority to manage the company. And F. The additional information necessary to appropriate and enable the department to carry out the chapter. 2. In lieu of the requirement of the filing application of the reinstatement is described in subsection 1, the Foreign Liability Company whose certificate authority has been revoked may submit all fees and penalties owed by the company to the restates rates were provided by the law at the time the company applies the reinstatement together with the current annual report signed by the registered agent and authorized representative of the company which contains the information described in subsection 1. If the department applies and if the department determines that the application reinstatement contains the information required under subsection 1 and 2 and the information is correct, upon the payment of all required fees and penalties, the department shall reinstate the Foreign Limited Liability Companies and certificate of authority. When a reinstatement becomes effective, it relates to the take of the effective date of the revocation of the authority. Foreign limited liability company may resume its activities and status as a revocation of the authority has occurred. The name of the foreign limited liability company whose certificate of authority has been revoked is viable of assumption, use, and other business and any until 1 year after the effective date of the revocation, unless the limited liability company provides the department with a record executed pursuant to statute 605-0203, which authorizes immediate assumption or use in its name and other limited liability companies. If the name of the foreign liability company applying for the reinstatement has lawfully assumed the state of another business entity, the department shall require a foreign limited liability to comply with the 605-0906 before accepting the application of reinstatement. 605-0910, withdrawal and cancellation of the certificate of authority. To cancel the certificate of authority to transfer the business to the state, the foreign limited liability company must deliver the department of the filing notice withdrawal certificate of authority. The certificate canceled, the notice becomes effective pursuant to 605-0207. The notice of withdrawal certificate authority must be signed and authorized representative state of the filing. The name of the foreign limited liability company as it appears at the record of the department, the name of the foreign liability current company's jurisdiction of formation, the date of the foreign limited liability company was authorized to transact business in the state. The foreign limited liability company is withdrawing certificate of authority in the state. 605-0911, withdrawal, deemed conversion of domestic filing entry. Registered foreign limited liability company that converts the domestic limited liability company to another domestic entity, organized, incorporated, registered, otherwise formed through the delivery of a record or department is for the filing of deemed is withdrawn, and a certificate of an authority is effective the date of the conversion. 605-9112, withdrawal, dissolution, merger, conversion, down-filing. Any registered foreign limited liability company has dissolved and completed winding up, has merged in the foreign entity and has not registered in the state and converted the domestic foreign entity and organized, incorporated, registered, otherwise through the public filing of the record shall deliver the withdrawal certificate of authority of the department filing in accordance with 605-0910. With the withdrawal section of foreign entity the converted to another type of entity and effective service of the process and action proceeding the base of the cause of the action arising during the time the foreign limited liability company was registered to do business with the state made pursuant to 605-0117. 605-09113, action of the Department of Legal Affairs. The Department of Legal Affairs may maintain action to enjoy foreign limited liability company for the transaction business of the state violation company of the violation of the chapter. 605-1001, relationship provision, section 605-1002, 605-1072, and other laws. The provision of the section 605 605-1002, 605-1072 does not authorize, prohibited by, it does not affect the application requirements of the law other than provision, selection, and transaction effected under the section 605-1002 to 605-1072 may not create an impaired right of the obligation with the part of the person under the provision of the law of state other than this section 605-1002 to 605-1072 relating to the change in control, taking over the business, contribution, control, share, acquisition, similar transaction involving merger, acquiring, converting domestic business corporation unless the corporation does not survive transaction satisfies the requirements of the provision. If the corporation survives transaction, the approval plan is the vote for the shareholders, directors which would hold sufficient create and impair the right of the obligation directly under the provisions. 605-1002, charitable and donative provision. Property held for the charitable purpose under the state of the domestic, foreign, and intermediate for transaction under the chapter becomes effective may not result in the end result of the transaction be diverted from the objects in which it is donated, granted, or devised otherwise transferred unless the extent of the required under the pursuant of the law state, the cypress or other law dealing with a non-diversion charitable asset, the entity obtains the appropriate order, the appropriate court certificate specifying the disposition of the property. 2. A bequest, device, or grant, gift or grant promises contained in the will of instrument, donation, subscription, convenience. This is made merging at the end is not in surviving entity that takes effect and remains payable after the merger and requires the surviving entity. True obligation was governed properly and transferred. Non-surviving entity applies to the property transferred for the surviving entity section. 605-1003 status of filings. After filing 605-01-1001 through 605-1072, signed the domestic entity becomes the public organic record of the entity. Entity's organic law provides the similar filings under the law becomes the public organic record of the entity. 605-1004 non-exclusivity. The fact that the transaction 605-1001, 605-1072 produces certain results does not preclude the same result being accomplished in any other manner authorized under the law of the provision. 605-1005, reference of external facts. The plan may prefer the facts of external outside plan in the manner in which the facts will operate upon the plan as specified in the plan. The facts may include the occurrence of an event and the determination of accordance determination action of the person, whether or not the event determination action will be the control of the party in the transaction. 605-1007 appraisal rights. Remember, the limited liability company is entitled to appraisal rights to obtain the payment of the fair value of the member's membership interest of the following events: consumption of the measure of the limited liability company pursuant to the chapter where the member possessed the right to vote on the merger; consumption of the conversion of such limited company pursuant to the chapter where the member possessed the right to vote upon the conversion; consumption of interest in exchange in the chapters where the membership possessed right to vote to interest exchange selective appraisal rights and are not available to the interest of the liability of the company whose interest of the liability company is not the subject of the exchange to the interest exchange. The consumption of the sale substantially all assets of the limited liability company were possessed at the right of the vote of the sale unless the sale is pursuant to the court order. The sale is for cash pursuant to the plan under which all net proceeds of the sale is distributed to the interest holders within 1 year after the date. The amendment of the organic rules of the entity reduces the interest of the holder. A fraction of the interest of the limited liability company will obligated but will have the right to purchase the fractional interest of the created. F. The amendment of the organic rules of the entity, the effect of which they alter and abolish the voting of the other rights of respect to such interest of the manner of the adverse interest, such as the member, except for the right that may be affected by the voting or other rights of the new interest being authorized in new classes of interest, new class or series of interest. G. Amendment of the organic rules of the effect of which adversely affecting the interest member, the altering, abolishing appraisal rights under Section H to extent otherwise expressly authorized organic rules of limited liability company. 2. A limited liability company modify the restrict eliminate the appraisal rights provided by the section organic rules provision modifying restriction and elimination rights authorized by members who appraise the rights are being modified, restricted, eliminated. Organic rules contain expressive waivers of the appraisal rights of the proof of the member constituted the waiver of appraisal rights with respect to such member the extent provided with such organic rules. Through the extent of the appraisal rights, the available here and under 605-0167, 0161, 605-172 govern the procedures with respect to appraisal rights between limited liability companies and member. Notwithstanding subsection, the available appraisal rights must be limited in accordance with the following provision. A. The appraisal rights are not available for holders of the membership interest for the one covers the security statute 18B1A and B, or B, Security Acts of 1933, and trade in organized market part of the class series of at least 2,000 members, though other holders' market values at least $20 million. Exclusive value of such class series, the membership is held in limited liability company subsidiary, senior executive managers, beneficial members owning more than 10% of such a class series, and the membership interest issued in an open-ended management investment company registered in Security Exchange Commission under the Investment Company of the Act of 1940, subject to being redeemed to the option of the holder in net assets. B. Applicability of the paragraph A should be determined as the date of the fixed determine the members entitled to receive the notice and to the vote of the appraisal event. The date before the effective date of such approval such appraisal event, there is no meeting of the members to vote upon the appraisal event. The subject does not apply to appraisal rights must be available to pursuant subsection 1 any members who require the appraisal event to accept their membership and interest in anything other than the cash property interest and the entity satisfy standards provided in paragraph A at the time of the appraisal event becomes effective. The subsection does not apply to appraisal rights must be available pursuant to subsection 1 of the holder of the membership interest. 1. Any member of the interest limited liability company assets acquired and converted with merge and conversion otherwise pursuant to the appraisal event of the person or maybe affiliate or person is at any or at any time in 1 year immediately preceding approval of the appraisal event with the beneficial owner of the 24% or more of the interest in limited liability entitled to vote at the appraisal event, excluding such interest acquired pursuant to an offer that all interest as having such a voting right and such a offer was made in 1 year before appraisal event of the consideration same kind of the value equal to lesser than paid in the connection of the appraisal event. B. The direct indirectly has at any time the 1 year immediately preceding approval appraisal event had power contractual otherwise causing appointment and election of any of the senior electors managed the limited liability. 2. Any of the members interested in the limited liability company assets being acquired and converted with their merger or conversion otherwise pursuant to appraisal by the person affiliated with of a person who is at any time of the 1 year immediately preceding of the approval of appraisal event with a senior executive limited liability company of senior executive of affiliate limited liability company. And the senior executive will receive as a result of the limited liability company action as the final benefit not generally available at 2 members at other than. A. Employment, consulting, retirement, similar benefits established separately, not as part of the contemplation of the appraisal event. Employment, consulting, retirement, similar benefits established in contemplation as part of the appraisal event, which are more favorable with the existing of the appraisal event and more favorable with the approval with a limited liability company. Or C. In the case of the manager of a limited liability company who will, during the result of the appraisal event, become a manager, general partner, or the director of the surveying converted entity or one of its affiliates, the rights and benefits of manager, general part of the director are provided with the same bias as those offered by the surviving converted entity, other generals, members, and general partners, directors of the surviving converted entity affiliated. The purpose of the subparagraph, the benefit owner means the person who directly, indirectly, through the contract agreement understands that other than revocable proxies has or shares the right to vote, to direct the voting of the interest of the limited liability company with respect to the approval of the appraisal event. However, the member of the National Securities Exchange may not be deemed the beneficial owner of the interest of the limited liability company held directly under the indirectly by the behalf of another person solely with the member of the record holder of the interest of the limited liability company if the member is precluded with the rules of such exchange from the voting without instruction contested with the matters that may substantially affect the rights and the privileges holders interest in limited liability company to vote. If 2 or more persons agree together with the purpose of voting such an interest, each member of the group formed thereby is deemed acquired beneficial ownership at the date of such agreements, the voting interest of the limited liability company beneficial owned by a member of the members of the group. 6051021. Member merger authorized by complying with the provisions of section 6051022 and 6051026. One of the domestic limited liability companies may merge from one or more domestic foreign entities and domestic foreign service entity. 2 or more of the foreign entities may merge in domestic limited liability company by complying with the provisions of section 6051022 to 6051026, which are applicable to foreign entities. The foreign entity may party with the merger under the provision of section 6051002 or 1022, 605, 1026 may be surviving entities and such a merging of the merger authorized by the law office, foreign entity and jurisdiction formation. In the case of the merger involving a limited liability company with a nonprofit company, surviving limited liability company or other business must not be for nonprofit entity. 6051022 plan a merger domestic liability company may become a partner to the merger under the provision of 6051021, 6051026 to provide planning of the merger. The plan must be in record containing the following as to each of the maintaining of the name, jurisdiction, formation, and type of the entity surviving the entity is merged, the manner, the basis of the converting the interest to the right to acquire the interest and act each party to the merge and the interest, securities, obligations, money, and other parties the rights to acquire interest of the security in any combination of the foregoing. If the surviving existing before the merger and proposed amendment to the reinstatement of the public organic record, the proposed amendment to the reinstatement of the private organic rules which are proposed to be recorded, and all such amendments to the reinstatement of the act effective the effective date of the merger, the surviving entities to be created with the merger and proposed public organic record of the full text of the private organic rules of the proposed and to be recorded if and any of the other terms, conditions of merger, any of the provisions required for the law of merging entities, jurisdiction formation, organic rules, and entity in addition with requirements under the subsection 1 plan of the merger may be contained any other provision not prohibited by law. 605.123 605-1023 approval of the merger. A plan of the merger is not effective unless it has been approved with respect to domestic merging limited liability company, the major interest of the members, the main record of each member of the merging limited liability company, which will have the interest of the holder limited liability debts, obligation limited liabilities that arise with the merger becomes effective unless the organic rules of the company and record provide with approval of the merger, in which some of all the times becomes subject to interest that hold the liability of the voter consent of the fewer than all the members. The member consented with the record of vote of the provision of organic rules becomes a member of the adoption of the provincial. 2. The merger involving the domestic merging entrant entity that not limited to the company is effective unless this merger is improved in the entity in accordance with the organic law. 3. The merger involving the foreign merging entity effective unless the merger is approved for the foreign entity in accordance with the law of foreign entity jurisdiction formation. 4. All members of the domestic liability company that is part of the merger who have the right to the vote of the merger must have given them notice of the meeting in respect to the approval of the plan of the merger as provided in subsection 1 and not less than 10 days but not more than 60 days before the date of the meeting which plan the merger is submitted with the approval of the member such as the limited liability company. Notification required under the subsection be waived written by the person entitled by this notification. 5. The notification required under subsection 4 must be written must not include the following: the date, time, and place of the meeting in which the plans merger is submitted to the approval of the members of limited liability. B. A copy of the plan of the marriage. 5. C. The statement of the required by the 605-1006, 605-1061, 605-1072. Availability of appraisal rights to the members of limited liability. The date of such notification was mailed and delivered into the members. 6. The additional requirements under subsection 5 required under subsection 4 and may contain the information concerning the plan of the merger prohibited by the applicable law. 7. The notification required under the subsection 4 deemed is given in the earliest date of the date of such notification is received. 5 days after the date of such notification is deposited in the United States mail addressed to member the member's address and appears in the books and the records of the limited liability company where postage affixed. The date should be shown on the return receipt if registered certified mail return receipt requested and receipt is assigned on behalf of the addressee. The date of such notification is in accordance with the provision of organic rules and limited liability companies. 605-1024 amendment of the plan of the merger. A plan of the merger is amended with the consistent with each part of the plan of the except for the otherwise provided with the plan of organic rules of the such entities. 2. The merging limited liability may approve the amendment of the plan of the merger. A. The same manner the plan was approved. The plan does not provide the same manner in which it is amended. B. The managers of members in the manner provided in the plan but a member who has been entitled to vote consent with the approval merger is entitled to vote of the consent with the amendment of the plan of the change. 1. Amount the kind of the interest, security, obligations, money, and other properties, right to acquire the interest, security, and other combinations for going to receive or interest of holders of any party of the plan. 2. The public organic record, if any, of the private organic record of the surviving entity will be in effect with the immediate merger becomes effective except for the change that does not require approval interest holder of the surviving entity under this organic law or organic rules. 3. Any other term, conditions, other plan that, if and change, would adversely affect the member in any particular matter respect. After a plan of merger has been approved before the articles of merger become effective, the plan abandoned with the provided in the plan used the prohibited plan of the domestic merging limited liability company has abandoned with the plan in the same manner as the plan was approved. 4. If the Plan merger is abandoned, but the articles have been delivered to the Department of the Filing, and but before such articles of merger have been effective, the statement of the abandonment, signed by a party of the plan, must be delivered by the Department of the Filing before the articles of merger become effective. The statement of abandonment takes effect on the filing. The merger of the abandoned does not become effective. The statement of abandonment must contain the following: the name of each party on the plan merger, the date of which the articles of merger was delivered in the Department of the Filing. Statement of the merger has abandoned in accordance with section 605-1025 Articles of Merger. After the plan of the merger is approved, the articles of merger must be signed at each of the merging entity delivered in the Department of the Filing. Articles of merger contain the following: the merger name, jurisdiction, formation, type of the entity, each of the merging entity is not a surviving entity. The name of the jurisdiction, formation, type of the entity, surviving entity. The statement of the merger was approved with the domestic merging entity that is limited liability in accordance with the provision of 605-1021 through 605-1022. Be each of the emerging entity, if in accordance with the law of its jurisdiction formation, each of the members of this such limited company would result in the merger will have the interest holder liability 605-1023 1B, whose approval is required. If surviving the entity exists before the merger of the domestic filing entity, the amendment of the public organic record approved as part of the planned merger. If surviving entity is created by the merger, domestic filing entity is public organic record is attached. The survival entity is created the merger domestic limited liability partnership or domestic limited liability limited partnership. Its statement of qualification as an attachment. A surviving entity, foreign entity that does not have a certificate of authority to transact business in the state. A mailing address to the department may send processes served to the department pursuant to 605-0117 or Chapter 48. Statement of surviving the entity has agreed to pay any of the members of limited liability for the appraisal rights of the amount of which such members are entitled under the provision 605-1006, 605-1061, 605-1072. The effective date of the merger. The effective date of the merger is the same as the date of the filing of articles of the merger, subject to identification 605-207. In addition, with the requirements of the subsection, the articles of merger may contain any of the provisions prohibited by law. A merger becomes effective with the articles of merger because unless the articles specify the effective time, date, and effective date of the complies with 605-207, the comply with the copy of the articles certified by the department may be filed with the official records. Any of the county, state, at which any of the part of the merger holds the interest in real property. The limited liability company is not required to deliver articles merger filed pursuant to subsections of limited liability company name, the merger entity, surviving entities, merger certificate, merger filed, the same merger according to 607, 1109, 617, 1108, 620, 108, 620, 8918. 3. If the articles or merger certificate merger substantially complies with requirements subsection, in the case other articles merger certificate merger may also be proposed in subsection F. 5. 605-106 effective merger. When a merger becomes effective, the surviving entity becomes existent. Each of the merging entity that is not surviving entity ceases to exist. All property that each merging entity vests in the surviving entity without transferring, reversion, and impairment. All debt, obligation, liabilities each merging that are the debt, obligations, and other liabilities survivor entities. Express otherwise provided by the law man of merger. All rights and privileges, immunity, powers, and purposes of each merging entity vests in surviving entities. After the surviving entity exists in the merger, 1. All property continues to be vested without transfer, reversion, impairment. 2. It remains subject to all the debts, obligations, and liabilities. All other rights and privileges, immunities, powers, and purposes continue to be vested in. G. The name of the surviving entity may be substituted by the name of the merging entity that is a party depending on the action proceeding. H. Surviving entity exists before the merger. It is public organic record that may be amended provided articles of merger. The private organic rules are that they may be may be recorded and amended with the extended provided with the plan of the merger. I. The surviving entity created by the merger of the public organic record, if in any effect, then private organic record rules are in effect. The interest of the rights of the occurring interest of the merging entity is which in converted with the merger. Converted interest holders holds interest entitled with the other writers and the provided with the planned merger to any of the appraisals that have in say it is statute 605-1006, 605-1061, 605-1072 merger entities of organic law. 2. Accept the other otherwise provided by the organic or organic rules merging entity. The merge does not give up to any of the rights, interest holder, governor, third party within the dissolution, liquidation, winding of the merging entity. The merging entity required to wind up its affairs and pay its liabilities, distribute its assets under 611050701, 6050717. The merger shall constitute dissolution merger. When the merger becomes effective, the person who did not have interest in the holder liability respects the merger entities becomes the subject interest of the holder liability to respect the documentation. The domestic entity resulting in the merger which have interest in the holder liability on the extent of the provided with the organic law of the entity's other debts, obligations, liabilities that arise from the merger effective. 4. The merger becomes effective in the interest of the holder of liability of the person who ceases to hold the interest of the domestic merging entity, the respect of which the person has the interest of the holding liability as follows. The merger does not discharge the interest holder liability under the organic law of the domestic merging existing interest holder for liability arose from the merger became effective. If the person does not have the interest liability under the organic law of the domestic emerging entity, debt, obligation, or other liability arising from the merger becomes effective. See the organic law of domestic mergers entity, any rights of contribution provided under such organic laws, organic rules of merging entity continuing to apply to the release, collection, discharge any of the interest holder liability preserved by 6A, and if merger has been occurred, the surviving entity with the domestic merging entity. When the merging becomes effective, the foreign entity of the surviving entity may be served to process the state collection, enforcing the debts, obligation, and other liability domestic merging entities provided by 605-0117, Chapter 48. When merging becomes effective, certificate authority to transact business in the state of the foreign merging entity is not surviving entity is canceled. 605-1031, interest exchange authorized. By complying with the provisions of Section 605-1032 and 605-136, the domestic liability company may acquire for all one of the more classes series of interest and other domestic foreign entity rights to acquire one or more classes series of such interest in exchange to interest, securities, obligation, money, and other prior property rights to acquire the interest, securities, and combination foregoing. All one more of the class series and interest domestic limited liability company requires to acquire one or more of the classes of such interest to be acquired in another domestic foreign entity in exchange for the interest, securities, obligation as money, and the other parties to acquire the interest, securities, combinations for foregoing by complying with the provision of the Section 605-1032, 605-1037. Yeah. Domestic limited liability may acquire for the one or more classes series of the interest on other 605-0131 interest of exchange authorized. By complying with the provision section 605-1032, 605-1036, domestic limited liability company may acquire for all one of the more classes series of the interest domestic foreign entity the rights to acquire one or more of the classes series. Such interest is in exchange in the interest, security, obligations, money, the property, the right to acquire the interest, securities in combination foregoing. All the one or more of the classes interest of domestic limited liability company the rights to acquire the one or more classes series of such interests may be acquired in another domestic foreign entity. The exchange, the interest, securities, obligations, money, and other property rights to acquire interest, securities, and obligation foregoing by complying with the provisions section 605-132, 605-136, which are applicable foreign entities. Foreign entity may be acquired the acquired entity of the interest exchange and completed with the provisions section 605-1032, 605-136, interest exchange with authorized organic law in the foreign entity jurisdiction formation. If a protected agreement contains the provision that applies to the merger to domestic and limited liability company but does not refer to the interest exchange, the provision applies to the interest exchange to domestic limited liability company acquired any of the interest and exchange merger provisions after January 2014. 605-1032, plan of interest exchange. Domestic limited liability acquired for the interest exchange on the provision 605-1031 through 605-1036 for approving the plan and interest exchange. The plan must be in a record containing the following: the name of the acquired entity, the name of the jurisdiction, formation type of the entity, acquired entity, the manner of the basic converting of the interest, the rights of the acquired interest of the members of each limited liability is to be acquired entity, the interest, securities, obligation, money, and other property right to acquire interest in entities, securities, or a combination of the foregoing. If the record entity is domestic limited liability company, proposed amendment of the reinstatement of the public organic record amendments and reinstatement of the provided organic rules that are proposed, the record and all such amendments to the reinstatement of the effective date of the interest exchange, the other terms and conditions of interest exchange, any other provisions required for the law of the acquired entity jurisdiction formation, organic rules of acquired entity, the organic rules of acquiring entity, the law of the jurisdiction formation acquired entity. In addition, for the requirement subsection 1, plan the interest change of the containing any other provision of not prohibited by law. 605-1033, approval interest exchange. The plan of the interest exchange is not effective unless it has been approved. When the respective domestic limited liability company with the acquired entity of the interest exchange of major interest and majority in interest of the members of such of a company, and a record of each member of the domestic acquired limited liability company that will be as interest in the holder limited liability obligations, other liabilities arise. The interest exchange becomes effective unless the organic rules of the company record provides approval of the interest exchange. Merger in some of all members become subject to interest of holder liability and vote with the consent of 3 or more of the members. The member consented in the record voted the provision organic rules become as a member of the opt-option of the provision. Interest exchanging involving domestic acquired entity with the limited liability is not effective with the approved domestic entity in accordance with the rigid organic law. 3. An interest exchange involving foreign acquired entity is not effective unless it is approved with the foreign entity in accordance with the foreign law of foreign entity's jurisdiction formation, except for otherwise provided with the organic law or organic rules. The interest holder acquiring for the entity is not required to approve the interest exchange. 5. All members of each domestic limited liability company that parts in the interest exchange with the right of vote upon the interest exchange must be given the right of notice meeting the respective approval of the plan of the interest change that provided in subsection 1 of less than 90 days, more than 60 days before the date of the meeting of the plan interesting exchange submitted with approval of members of such limited liability company. The notification required in the subsection may be waived in writing with the person entitled to such notification. The notification required under subsection 5 must include the following: the date of the time, place of the meeting in which the place of the interest is to be exchanged, submitted by the approval of the member of the limited liability, a copy of the plan of the interest exchange, the statement of the required of 605-1006, 605-1006-01, 605-1072 regarding the availability appraisal if any of the members of the limited liability company. D. The date of the notification of the voice mail delivered to the members. 7. In addition, with the requirements of subsection 6, the notification required under the subsection 5 may contain information concerning the plan interest exchange not prohibited to applicable law. 8. Notification required under subsection 5 of the deemed is given to the earliest date, the date of the notification received. 5. The date of such notification deposited in the United States address when the member of the address appears in the books and record of the limited liability company of the prepaid affix. The date of shown of the return receipt, if sent with the registered certified return receipt requested the receipt signally behalf of the address. The date of sufficient such notification is given in accordance with provisional organic rules and limited liability company. 605-1034, amendment and abandonment of the plan of interest. And plan of interest may be exchanged, may be amended only with the consent of each party of the plan, except for the otherwise provided within the plan or organic rules for such entity. The domestic acquired limited liability company may approve the amendment of the plan of an interest exchange. The same manner the plan was approved. If the plan does not provide the manner with which amended to the managers or the members in the manner provided with the plan, the member who is entitled to vote consented to approve the interest exchange to vote on the consent of the amendment with the plan with the exchange with the change. The amount or kind of interest, securities, obligation, money, and other parties' rights to acquire the interest, security, and obligate, and the combination foregoing to be received interest holders to as many party of the plan. The public and organic record, if any of the private organic rules of the acquired entity will be ineffective immediately after the interest exchange become effective, except for the changes to do the required approval interest holder that required under this organic law or organic rules. 3. Any other term of the conditions of the plan and change that adversely affected the member in the many material respects. After the plan interest of the exchange has been approved before the sum of the articles of interest exchange that become effective, the plan abandoned but is provided with the plan and prohibited by the plan. A domestic limited liability company may be abandoned by the plan in the same manner as the plan approved. 4. If the planned interest exchange abandoned the first after the articles, if the planned interest exchange abandons after articles of interest exchange have been delivered to the Department of the Filing before the such articles of interest exchange have become effective, the statement of abandonment signed by the parties of the plan may be delivered to the Department of the Filing before the articles of the interest exchange become effective. The statement of abandonment takes effect of the filing. The interest exchange is abandoned but does not become effective. The statement of abandonment must contain the following: the name of each of the party of the plan of the interest exchange, the name of the date of the articles of interest exchange where delivered to the Department of the Filing, the statement of the interest exchange of the abandonment of the accordance with this section. 605-1035, articles of interest exchange. After the plan of interest exchange have been approved, articles of interest exchange must be signed to each authority interest exchange delivered to the Department of the Filing. The articles of interest exchange must contain the following: name of the acquired limited liability company, name of jurisdiction, formation, title of the entity acquiring entity, a statement of the plan of interest exchange which will approve the acquired limited liability entity of the accordance with the provision of 605-1031 through 605-1036. Each member of such a limited liability company whose as a result of the interest exchange will interest holder liability of 605-1033 1B and whose approval of the required amendments to the required limited liability company's public organic records approved as part of the plan of interest exchange. A statement of the plan of interest exchange was approved according to any of the party of the interest exchange in accordance with the organic law, jurisdiction, formation, such as approval is required, and the statement is a fact. 5. A statement acquiring for the entity such as agreed to pay the member of the acquired of the entity of the appraisal rights of the amount on the such members that are entitled to 605-1006, 605-1061, 605-1072. The effective date of the interest exchange. The effective date of the interest exchange is not the same as the date of the filing articles of interest exchange, subject to the limitations to 605-0207. In addition to the requirements of the subsection, the articles of interest exchange may include in other provisions that not prohibited by law. Entry and interest exchange may become effective when the articles of interest becomes effective unless the articles of interest exchange specify effective time and delayed effective the date that complies with 605-0207. Limited liability company required to deliver articles of interest exchange filing pursuant to subsection 1 of the domestic liability company is named acquired entity as acquiring entity articles exchange filed with the same interest exchange in accordance with 607-1105. 1. If the articles are share exchange substantially comply with the requirements of this section. 605-1036 effect, or 605-1036 effective interest exchange. When interest exchange in which the acquired entity domestic limited liability company becomes effective the interest domestic company which is subject to the interest exchange succeeds the existing converted exchange members of these whole entities entitled with the rights to be provided under the plan interest exchange to appraise the rights under the statute 605-106, 605-161, 605-172. Acquiring the entity becomes the interest holder interest of the acquired entity, the plan of the interest exchange to become the acquired of the entity, the public organic acquired of the entity is amended with the provided articles interest exchange. The provision of the private organic rules of the required entity that has become required of the amendment with the extent of the provided with the plan of interest, except for the otherwise provided in the organic rules required by the limited liability company interest exchange does not rise to any rights of the members manager of the third party who's having a dissolution or liquidation with the dwindling of the acquired entity. 3. When the interest exchange becomes effective, the person who did not have the interest holder liability with respect to the domestic acquired limited liability company who becomes the subject interest holder liability with respect to domestic entity as a result interest exchange to have the interest holder the limit liability one of the extent that provided the organic law that only those debt obligation limited liabilities arise when the interest exchange becomes effective. 4. When the interest becomes effective, the interest liability the interest holder the liability of the person ceases to hold the interest of domestic acquired limited liability company with respect with the so the interested holder liability as follows. The interest or exchange does not discharge any of the interest holder liability to the extent of the interest holder liability before its interest exchange becomes effective. The person does not have interest holder liability for a debt obligation or other liability that arises in interest exchange effective. The organic law acquired for the jurisdiction formulation rights of the contribution provided by the subject such a law organic rules of acquired entity continuing apply to the release collection discharge of the interest liability preserved in paragraph A, this interest exchange has not occurred. 605-1041 or 1041. Conversion authorized. Complying with the provision of the Section 605 1042, 605 1046, the domestic limited liability company has become has become a domestic entity with a different type of entity, foreign entity with a limited liability company, different entity if in the conversion authorized with the law of foreign entity jurisdiction and formation, complying with the provision of Section 6 Statute 605 1042, Section 6 State Statute 605 1046, which are applicable to domestic entity with a domestic limited liability company. Domestic entity becomes a domestic limited liability company if the conversion of the authorized law governing the domestic entity becomes complying with the provision Section 605 1042 and 603 through 6005 1046, which are applicable foreign entities. The foreign entities may become the domestic limited liability company if in company version it may be the law of foreign entity jurisdiction formulation. The protected agreements conversion applies to the merger of domestic limited liability or does not refer to the conversion of applies to the conversion of any conversion until the provision is amended in January 1st, 2014. Through 605-1042, the plan of conversion of domestic limited liability company may convert the different type of the domestic entity and foreign entity. The foreign limited liability company, different type of the foreign entity. The proving the plan for the conversion of the plan must be recorded and contained in the following: name of the converting limited liability company, the name of the jurisdiction, formation, type of the entity, converted entity, the manner, basis of converting, interested, rights to acquire the interest of converting limited liability company to the top into interest, security, obligations, money, other property, right to acquire the interest, securities, in combination foregoing, the proposed public organic record of the converted equity in the filing entity, the following text of the private organic rules of the converted entity, of the proposed to be in a record, if any, and other provision required for the law of the state organic rules converted with the limited liability, if in the entity to become any other domestic limited liability company. And all other statements required to be set forth in the plan conservation of the jurisdiction formation converted in an entity following the conservation. In addition, with requirements subsection 1 of plan conservation may be any other person provision not by law. 605-1043, approval of the conversion. A plan of the conversion is not effective unless it has been approved if the converting of the domestic limited liability company and majority in the interest of the members of such company with the right of a vote upon the conversion. In record, each member of the converting limited liability company will have the interest holder liability, debts, obligation, other the liabilities as the rise. The conversion becomes effective unless the organic rules of the company have record of the provided with approval conversion, in which some of all its members become subject to the interest of the holder of liability by the vote of consent by less than all the other members. The members consisted in a record of the voted in provisions of the organic rules that became the member of the adoption of the provision. The conversion of the involving the request domestic converting an entity that must be not limited to the company, not effective unless improved with domestic converting entity in accordance with the organic 3. The conversion of foreign converting entity is not effective unless it is approved with the foreign entity in accordance with the law of the foreign entity jurisdiction formation. 4. If any of the converting entity is domestic limited liability company, all members of the company who have the right to vote upon the conservation must be granted, given the written notice, a meeting of the request of the approval of the plan of the conversion of the provided subsection 1 of the number of 10 days, not more than 60 days before the date of the meeting of the day at which the plan of the conversion is submitted with the approval of the members of the limited liability company. Notification required under the subsection waived the writing in the person of the person or the persons entitled to such notification. The notification required under subsection 4 must be in written, including the following: the date, the time, the place of the meeting, right, which of the plan of the conversion submitted with the approval of the members of the limited liability company, the company of the plan of the conservation of the city. The statements required with 605-1006 through 605-161 through 72 regarding the availability of appraisal rights, and if any members of the limited liability company date of such notifications mailed delivered to the members. In addition with the requirements of the subsection, the notification required for the subsection may contain the information concerning the plan of the conservation prohibited by the applicable law. Notification under the subsection 4 is deemed to give in the earliest date of the date of the notification received 5 days after the notification is deposited in the United States mail addressed to the member's address. It appears that the books and the record of the limited liability company were prepaid, posted, or fixed. The date shown on the return of receipt is sent by the registered certified mail. Return of the receipt. Request of the receipt is assigned on the behalf of the addressee. The date of the notification is given in accordance with the organic rules of the limited liability company. 605, 1044, amendment of the abandonment of the plan of the conversion. The plan of conversion, domestic converting limited liability company may be amended in the same manner as the plan was approved. The plan does not provide the manner in which it is intended. The plan or by the manager's members of the entity provided the plan, but the member was entitled to the vote. Consent to the approval of the conversion is entitled to vote, and consent to the amendment of the plan will be changed. The amount of the kind of the interest and the obligation money of the other party, right to acquire the interest securities, any other combination foregoing to receive the interest holders and converting entity under this plan. The public organic record, if any of the private organic record, all the rules and converted, which will be in effect immediately the conversion becomes effective, except for the change did not require approval of the interest holder converting the effective under its organic law or organic rules. Any other terms of the condition if plan of the change will adversely affect the interest holder in the material respects. After the plan conversion has been approved before the article in conversion becomes effective, the plan may be abandoned. Provision plan, unless the prohibited by a plan domestic converting limited liability company may be abandoned in the same manner the plan was approved. If a plan conversion abandoned articles and conversion are delivered at the date of the filing, such articles of conversion have been effective the state of the abandonment signed by the converting entity delivered by the department of the filing. Articles conversion of the effect of the state of the abandonment taking the effect of the filing. Conversion of abandonment does not become effective the same, and abandonment must contain the following: the name of the converted limited liability company, the date of the articles of conversion were delivered in the department of the filing, as in the statement of the conversion has been abandoned in accordance with section 605, 1044. Articles of conversion. After the plan of the conversion is approved, the articles of conversion are signed. The converting entity was delivered to the department of filing. The articles of conversion must contain the following: the name, jurisdiction, formation, type of the entity of the converting entity, the name of the jurisdiction, formation, and type of the entity of the converted entity. The converted entity in the district of limited liability company statement of the plan of the conversion has been approved. The accordance to 605, 1041 through 605, 1046. And converting entity informed the entity of the statement of the conversion was approved. The foreign converting entity with accordance with the law of the jurisdiction formation. Each member of the converting entity who has resulted in conversion with the interest of the holder liability 605 1043 1B and whose approval is required and converted with the entity's domestic filing entity. The tax of the public organic record is an attachment of the converted, but the entity is domestic limited liability partnership of shipment. His qualification is an attachment of the converted entity for it, and the entity does not have a certificate of authority, transaction, business, and state mailing address. The department may send and process served department as pursuant to 605 1017 605 0117 and chapter 48 statement of the conversion entity with the degree to pay the members of the United States liability company approved appraisal rights for the amount of much such members entitled under the statute 605 1006 605 1061 605 1072. The effective date of the conversion, the effective of the conversion, the same the date of the name the filing articles, which are the limitations of 6050207. In addition, with the requirements of subsection 2, the articles of conversion may contain the provision prohibited law. Conversion may become effective with the article. Conversion may be effective with the articles of conversion specifically and effective at the time of the date and the effective date of the complies with statute 6050207. A copy of the articles of conversion certified by the department may be filed with the official records if in any of the county in the state which was converted by the entity holds in the interest in the real property. 605-106 effective conversion. When the conversion is which the converted entity's domestic limited liability company becomes effective, the converted entity organized under the subject of this chapter, the same entity without interruption, the converting entity, all property of the converting entity continues to be invested in the converted entity without transfer revisions and impairment. All debits, obligation, other liabilities, converting entity that continues about debt, obligation, other liability, converted entity, except otherwise provided by the law or plan of the conservation or the conversion of all the rights of the privilege, immunities, powers, purpose of the converting entity remain the converted entity. The name of the converted entity may be substituted the name of the converting entity in any pending action proceeding. F. The provision of the organic rules of the converted entity, which are to be in the record and any provided with the part of this plan conversion as effective. The G. The interest of the rights acquired, the interest of the converting entity are converted, the interest holder converting entity are entitled to the provided under them under the conversion to appraisal rights that are under section 605-1006 and 605-1061 through 605 1072. and converting entity's organic law, except otherwise provided with the private organic rules of domestic converting limited liability. The conversion does not give up any of the rights of the member, manager, or third party will otherwise dissolution, liquidation, winding up the converting up entity, which of the conversion becomes effective. The person who did not interest holder liability with respect to the converting and becomes the subject interest holder liability with respect to the domestic entity. As a result of the conversion, has the interest holder liability to only the extent of the provided by the organic law and entity, only for the debts, obligation, and other liabilities that arise in the conversion before becomes effective. For the conversion becomes effective, the interest holding liability because the sees that hold the interest domestic limited liability company respect with the persons that interest holder. This is followed. The conservation does not discharge interest holder liability to the extent of the interest holder liability if it arose before the conservation became effective. The person does not hold the interest holder liability for any of the debt, the obligation, limited liability that arises if the conversion becomes effective. The organic law of the jurisdiction, formation, of converting, and limited liability company has the right of contributing, provided with such a law, organic laws of converted limited liability continuing to apply the release and collection and discharge of any interest holder limited liability reserved for the paragraph A if in the conversion has been occurred. The 5 when the conversion becomes effective, the foreign entity, the converted entity becomes if it served the process of the state collection, enforcement, and debts, obligation, and liabilities are provided in 6050117 in Chapter 48. 6. In converting the entity and the stored and registered entity, the certificate authority conduct the business in state converting the entity is canceled. Conversion becomes effective. A conversion does not require entity to wind up its affairs and does not constitute cause dissolution of entity.